onto the Zoom
Yeah.
using the information that I found under this keyboard. As you, and is that what Tammy would have done?
I don't know what she does on that.
No, I came up and.
Oh, on this computer? Well, it's strange that I can't change the names.
Because this is what I did. I came and I used this icon and I signed in as you. And so if that's not what you normally do.
All right, let me try this then. Okay, who do I have at the phone number? It's well, I think we might have gotten kicked out now. I think my Zoom stopped working. Yeah. All right, I'm gonna just go ahead and open Zoom again. Oh, they're still.
Here's Mr. Lynch.
Mr. Lynch. Well, maybe that worked. Good morning. Hang on just a minute. I'm yeah, when you go in, always launch Google rather than go to Zoom on the bottom.
Okay.
I think that's probably.
Got it. Okay.
Now I know why.
Mm-hmm.
All right. So Mr. Lynch is now here. And I just want to make sure everyone else is still able to hear okay?
I can, Your Honor.
Okay, good.
Yeah.
Okay, this is strange. I got to go back in.
I do apologize, Your Honor. We were in a different meeting room, one that was on the Zoom instructions for the summons.
Oh. Well, I'm having a little difficulty myself, so, but I'm glad you were able to finally get in.
I believe Ms. Gunderson, our defendant, is also signing on.
Yes,
She
I'm
is.
here.
Okay, all right. Okay, so this is again file 217131LT1 22955 Investments versus Cheyenne Gunderson and other occupants of 2804 White Hill Lane. And Mr. Lynch is here on behalf of plaintiff. And Mr. Lynch, I don't know, maybe you had an opportunity to speak with Ms. Gunderson while you were in the other meeting room, or do you want to talk to her, or?
I would, Your Honor. I believe this would be the first hearing, this would be the pre-trial, but I have my plaintiff here as well on the iPhone, the representative of Plums, and we would like an opportunity to speak with Ms. Gunderson before the pre-trial, if that's all right.
Yep. Okay, so I'll go ahead and put all of you in a breakout room then, and Ms. Gunderson, and you'll need to accept the invitation that's going to pop up on your screen. So just look for that.
Okay.
All right, who do I have at phone number 231-492-5650?
That's me. Cheyenne.
Oh, you should have gone into a breakout room.
No, nothing ever popped up or said anything. I'm calling
All
and
right.
I'm not on.
Okay, well, let me go ahead and try putting you in the breakout room now, but I'm going to
Okay.
rename you first if I can.
Okay.
Let's see. And I don't know who I put in that room. 4998897.
That might be the,
That's not Rebecca because she's on the iPhone.
oh. Oh, it's probably Miss Taylor David, who's our 8:30 case. She was a 499 number, I believe.
Okay. All right, who do I have at 4998897?
This is Deborah, Your Honor. Deborah Taylor David.
Okay. All right, thank you. Okay, so let's go to that case then. And Ms. Abu, are you here on behalf of U.S. Bank?
Yes, I am, Your Honor.
No. I'm here. I'm the defendant.
Oh, no, I asked Ms. Abu, who's also, Albu, who's also on the line.
Oh,
Am
I'm
I
sorry.
pronouncing that correctly, Ms. Albu?
Yes, Your Honor.
Okay, good. All right, so this is U.S. Bank versus Deborah Ann Taylor and other occupants of 2439 McNabb Court in Traverse City. And Ms. Albu is here on behalf of the plaintiff. And Ms. Taylor is here representing herself. And let's see. Have you had discussions about the case recently, Ms. Albu, with the defendant? And is there any resolution, or would it be helpful to speak with her?
No, we have not talked recently, so yes, we could go to a breakout room.
Okay. I'm going to try to set that up then. Although I think I'm limited to one breakout room. Well, maybe not. Let's give it a try here. Did you get it? There she goes. All right.
Judge, could you spell her name for me, Albu?
ALBU.
Thank you. Wow, I would have never guessed.
All right, I see Mr. Lynch is back, so let me get the other meeting participants. All right, so Mr. Lynch, has there been any resolution of the case?
Your Honor, as I said before, this was the first hearing in a termination matter due to complaints. I've had an opportunity to speak with the defendant. She has contacted Mr. Koonman from Legal Services on Thursday of last week. Since this is a termination case and not a non-payment case, we will be looking to seek to proceed at this time with the pretrial and then hopefully get a new hearing after that. So that Ms. Gunderson has an opportunity to get legal counsel and prepare.
All right, so Ms. Gunderson, is that accurate? You're seeking legal counsel with Legal Services and through Mr. Koonman, and
Yes,
you
Your Honor.
understand and you should understand that I'm gonna adjourn this out to my next civil day, which is in 2 weeks, and you should be prepared for a hearing at that time, okay? So that means
Okay.
presentation of testimony and evidence.
Okay.
And I don't believe we've received any appearance from Mr. Koonman yet. So if for some reason Legal Services is not going to represent you, you have a right to seek other counsel. Otherwise, you'll be representing yourself at the hearing, okay?
Okay.
All right. Let's see. Anything else we need to cover, Mr. Lynch?
Not at this time, Your Honor.
Okay, so let's pick a date then. When is the next civil day?
Your next civil day would be August 2nd.
Okay, so August 2nd. And we'll set that for 10 o'clock since it appears to be more likely a hearing.
Thank you, Your Honor.
Is there anything else for you, Ms. Gunderson?
I don't believe so.
Okay, well, just make sure that you get in contact with Legal Services. Let them know what happened today. The sooner the better,
Okay.
because 2 weeks will come up quick, okay?
Yeah, I'll email
All
it
right.
now. Thank you.
Okay, and I want to thank Rebecca from 22955 Investments for being here as well. And thank you, Mr. Lynch and Ms. Gunderson, okay? You can
Yeah.
feel free to sign off at this time.
Thank you,
Okay,
Your
thank you.
Thank you, Your Honor. Have a good day.
Thank you. All right, and I see Mr. Stewart is here on the BC management case versus Desmond Harrington.
Correct, Your Honor.
And we're a little, good morning. And we're a little bit early on that case. I haven't seen Mr. Harrington sign in yet, so we'll probably give them at least until quarter after
Correct.
to see if they appear or not. So is there, I don't know if you've had recent discussions with them, Mr. Stewart?
Not really, Your Honor.
Whether it would it make sense to put you in a breakout room when they do, if he does get here?
I don't know that it would, Your Honor. I mean, my client's essentially just trying to get him out, trying to get a judgment for possession. You
Okay.
know, and they know that the lease has expired back in April. So it's kind of, there's been discussions, but I don't think they're going to go anywhere.
Okay. All right. Well, if you did want a breakout room, we can set that up, but otherwise we'll just figure out a hearing. So. This is strange. Now it says Bob Cooney is connecting to audio. He's not having much luck.
That is unusual. Like you didn't push any buttons to make it.
No, I just started doing.
And your computer doesn't have any audio anyhow.
Right. All right, I see Miss Albu is returned now, so I'm going to close the breakout room. Get Ms. Taylor back. All right, so we're back on file 185765, U.S. Bank versus Deborah Taylor. And I believe it's Deborah Taylor David.
Yes, Your Honor.
So, Ms. Albu, has there been any resolution?
No, Your Honor, so we will need to proceed with the hearing.
All right.
Your Honor, I talked to her. I want to be able to purchase my home back. I've been, fighting to save my home now for almost 4 years. And I did request a jury trial the last time when I talked to you, because I feel very strongly about my case. And so I was asking if there was any way possible that U.S. Bank would sell me back my home that I've lived in for 35 years, and I fought hard to save for the past almost 4 years due to fraudulent foreclosure. But anyways, I inherited my mother's estate in Ohio, Northern Ohio, and I'm in the process right now of putting that up for sale. So I would have cash to try and be able to buy my home from U.S. Bank. And so I was asking for 90 days to be able to, get my mother's place together and get that sold. And I just inherited it like a couple months ago. So, anyways, that's where I'm at right now.
Your Honor,
All right.
yes, if I may put some facts on the record as well.
Sure, go ahead, Ms. Albu.
Your Honor, this case involves a mortgage foreclosure. The sheriff's sale was actually held on March 21st, 2018. The redemption expired September 21, 2018. Your Honor, this case was filed back in 2019, in 2018, and the first hearing was January 14, 2019. I believe it would have been at that point that the defendant would have needed to request a jury trial at the first hearing. Your Honor,
Excuse me, what date was that again?
The first hearing was January 14th, 2019.
Okay, that
More
was the
than-
jury
Well,
request?
Well, she never requested a jury trial.
I'd never
Your Honor.
requested a
This is the
jury trial. No.
This is the first time she's making the request. Your
Right.
Honor, the defendant filed a case in federal court, which was dismissed by federal court, and she filed an appeal. The
That was
Court of Appeals.
due to technicalities. It
Oh,
wasn't even to do.
Hang on, Miss Taylor David.
I'm sorry. I'm sorry. I'm sorry.
Let's give Miss Albo a chance to speak, and then I'll give you a
Okay.
chance. Okay.
Okay.
So
Thank you.
go ahead, Miss Albo.
Yes, Your Honor. So the defendant appealed the federal court's decision. The Court of Appeals denied her request. So here we are today. I am petitioning the court for a judgment of possession. Your Honor, I have explained to the defendant, as I said, this case was filed more than 2 years ago. This is the first time the defendant has expressed her opinion, her request to purchase the home back. I cannot make a guarantee that this is an option. However, obviously, I can take that back to my client. In the meantime, I am petitioning for a judgment of possession because that may not be an option for whatever reason. I don't know. But in the meantime, she can work on either moving out or purchasing the home back if that's what my client agrees to. However, there is no defense to the action that the defendant has put forward in more than 2 years. And as I said, I'm renewing my request for a judgment of possession. I am willing to extend the vacate date. I explained to her we can work on maybe 30 days, but I cannot do 90 days.
Okay. Well, Miss Taylor, what is your defense to the fact that the redemption period has expired?
It's because I've had to fight in federal court, the Court of Appeals. They dismissed my case basically on technicalities. I have 11 counts of fraud. I have a very strong case. And the reason why I never offered to buy back my home is because I never had the money. And my mother passed away and I inherited her estate. And so it is in the process of being sold. And I don't want to have to buy my home back because I don't feel like I should. But I don't want to lose my home. I've lived here for almost 36 years now. And I have 5 kids. And so I'm just asking to have more time to try and buy my home back. And if not, I want to have a jury trial because I believe very strongly in my case. And that is the reason why I went pro se by myself to federal court, to the appeals court, and was dismissed on technicalities and not even looked at the real reason. The 11 counts said I had an audit done in Washington, D.C., and it's been a long ordeal for me.
All right. Well, foreclosure law isn't something that I would recommend going to court without an attorney.
Right, and that's what I want to have time
so
to
when
do.
you say a technicality, well, that's very possible because it's a very technical area of the law, and there are deadlines, and and there's very little discretion for a court to interfere with those deadlines. And
I understand.
So
I understand, Your Honor.
This is the thing. You may. Is there any reason why the right to a jury trial has been foreclosed? And even if it has, Ms. Alba, wouldn't you be entitled to summary disposition if the facts are as you've stated?
Your Honor, I believe there's, as I said, the defendant has pretty much lost her right to request a jury trial. That would have been at the first hearing. And as I said, that was over 2 years ago.
All right. So at this point, Ms. Taylor, I believe that the plaintiff is correct, that there's no right to a jury trial. The right was not asserted timely. And so what Ms. Albu is offering you is 30 days rather than the usual 10 days that would be allowed in this case to vacate. That may give you enough time if you're serious about purchasing the house yourself to get that funding in place.
Right.
So I don't know. Are you interested in having 30 days rather than the 10?
Yes.
What would be required is a consent judgment, which means you would be consenting to the possession judgment, but with the understanding you would have 30 days to move out. Is that what you want to do?
I would, I guess, meet.
All right. You would have 3 days to rescind the judgment because you're unrepresented by an attorney today. And that means you'd have to notify the court in writing somehow that you have decided after consulting with legal counsel that you no longer want to go along with the consent judgment. Do you understand that?
Okay.
The 3-day
Yes, I
right of
do.
rescission? Okay.
Right.
All right. Ms. Albu, is that still acceptable to you and your client?
Yes, Your Honor. I don't know if I should prepare the judgment. I can, with her permission, I can sign Ms. Taylor's name on the judgment and submit it to the court.
Okay. Does that sound okay, Ms. Taylor?
Yes, I guess at this point.
Okay. All right. Is there anything else that we need to take up at this point?
No, Your Honor.
Okay.
I don't.
Well, I think we're all set for this morning then, and the parties can feel free to sign off at this time, and I'll look for the consent judgment from you, Ms. Albu.
Thank you, Your Honor. Have a good day.
You too. Thank you.
Thank you, Your Honor.
Yep. All right, let's go to BC Management versus Desmond Harrington, and that's file 20217140 LT1. And Mr. Stewart is here on behalf of plaintiff. And is Mr. Harrington present?
Yes, Your Honor, I am. I'm present also, Your Honor, Mark Harrington.
Who's that?
Mark Harrington. I'm a co-leasee with Desmond.
Okay. Are you perhaps Desmond's father?
Yes, sir.
Okay. And you live at that, the 9979 North Long Lake Road address as well?
Yes, sir. We're both on the lease.
Okay. Are there any other tenants at that address?
No, sir.
Okay. So I've offered for Mr. Stewart to speak with you to see if this could be resolved. He didn't know if that would be helpful or not, but I don't know. What do you think?
I'm not sure if it will be. Basically, we got behind on rent when COVID came around. My son lost his job. He works as a cook. And some months went by. I got some assistance from the Veterans Administration. I'm a disabled veteran. I'm a disabled retired veteran. So I got some help from the VA. They helped us to get caught up, at which time our landlord said he would, in fact, continue to rent to us if we got caught up. The VA made sure, you know, that he would continue to rent to us if we could get caught up. So they helped us to get caught up. And during that time, I found out I had end-stage terminal cancer and was given 3 months to live. Now that was last year that came around, and I'm still alive. We've been looking for a place to move to. Excuse me. At that point, he iterated to us that he would not, in fact, renew our lease, and that we would have to move at the end of the lease. And we've been looking for a place. You know, money's not a problem. I received funds from the VA. We haven't found any place. You know, we would love to continue to live here. We certainly have the resources to do so. So I don't know if, with all those facts, you know, laid out, if speaking with Mr. Stewart would still be, if there'd be any sense to it or not.
All right, Mr. Stewart, what's the plaintiff's position, and has there been any discussion of relief under the SARA or CARES Act?
There hasn't, Your Honor. Like Mr. Harrington indicated, my client, you know, back in April of this year indicated that it was not going to renew the lease. The lease expired at the end of April. You know, my client attempted to start eviction proceedings back then, but didn't have the notice requirements accurate. So it got, you know, took a while to actually get to this point. You know, they haven't paid, or I think they've only partially paid for June. They haven't paid for July. At this point, Your Honor, my client's just looking for, you know, possession and an effort to evict them because, again, the lease has, you know, long expired. We gave them the 30 days notice. You know, it's unfortunate that they can't find another place, but at the same time, Your Honor, you know, my client has plans for this building, and so that's the reason why we're just looking for a judgment for possession.
All right. Well, I need to inform the Harringtons that you do have a right to seek legal counsel because this is a first hearing, and I would give you a 2-week adjournment if that's what you wanted to do, is get some legal advice and otherwise try to put together a plan here for defending the case. And let's see, is that something you want to do, or?
Yes, that's something we'd like to do, Your Honor. Doesn't it?
Yes, definitely.
I'm not sure of any of our rights on this.
All right. So what was that date again for?
August 2nd.
August 2nd is our next civil day. And so I'm going to adjourn this out until then. Now, what you have to be aware of is that I will take up a hearing on that date. And so evidence would be presented. Usually Mr. Stewart would show me or introduce a copy of the lease agreement that he says expired in March or April, and that there was no agreement to renew that lease and that you were behind in rent. And if you have a defense, you'd want to present it at that time through your own testimony or testimony of other witnesses and presentation of any documents or other evidence that might be relevant. Okay. I would advise you to seek legal assistance through Legal Services of Northern Michigan. And they do provide free legal services if you qualify, and financially, and also if they think you've got a case, they'll represent you. Okay.
Okay, Your Honor.
All right, but the clock is ticking. You've got 2 weeks, and there will be a hearing in that time. The other thing I would advise you to do is continue your efforts to find other housing and maybe work with some of the programs, the eviction diversion program, to see if there's some other way that this could be resolved, okay?
That sounds good, Your Honor.
All right. So is there anything else for you today, Mr. Stewart?
I don't think so, Your Honor. Will the court send out the notice for the adjourned hearing, which I assume will also be via Zoom?
Yes, you will get another notice in the mail, and the hearing will be the same as it was today by Zoom, okay?
Thank you, Your Honor.
Awesome.
All right, thank you. All right, feel free to sign off at this time. All right, let's go to file. Let's see. Two 17141 LT1 Bradley McClellan versus Jamie Dalkey. And do we have Mr. McClellan present? I see Mr. Dalkey is present, but I don't see Bradley McClellan. And let me ask, I see Jody's iPhone on the screen. What is your name, ma'am?
Jody Ferguson.
Okay. Are you here on this case?
No, I'm not. No.
I don't know what case she's here for.
Okay. Do you have a file number?
It's case number 217087 LT1.
Oh, that was the one. We heard that.
Ah, Meadow Lane.
Yes.
Okay. Did you, that hearing was at 8:15.
I realize
when were
that
you
now.
Okay.
I apologize, sir. I logged into this on Friday thinking that the 16th was the 19th, and for some reason I thought I was supposed to log on at 9 o'clock in the morning. So I'm at work and took a break I'm literally at work right now. But my case should have been resolved. The SARA program has notified me that they were going to pay whatever, and
all right. Are you asking to have, what happened is because you weren't here, I entered a default judgment. There was a representative of Meadow Lane here, Ms. Dornbush. She's the attorney for Meadow Lane.
But she should have known that it was, she should have known that it was paid.
Okay. Well, the fact there was a default doesn't necessarily mean that she wouldn't pursue the SARA program with you. But this is the thing, because you have appeared and you've indicated that you are making efforts to secure funds through the SARA program. Absolutely. I'm going to set aside the default. I want to let you know that we're going to adjourn this out to the next hearing date, which is August 2nd. At that time, I will allow Ms. Dornbush to address the default and whether that was properly entered, or whether, or I guess whether withdrawal is the appropriate remedy here, but also to reset this for a hearing. Now, what I would do is have you or your attorney, are you working with legal services? You're just
No.
handling it on your own?
I'm just handling it on my own.
Okay, what I would do is contact Meadow Lane and let them know that you did appear and you think there's been a mistake, because, and tell them Judge Cooney set aside the default for now,
Okay.
and that you're working with the SARA program, and you're not sure why the attorney asked for the default because of that, okay? But we will be back for a hearing on that date, August 2nd. So you need to be prepared at that time to go forward. I'll advise you once again, you have a right to an attorney, and it may make sense for you to consult with Legal Services of Northwest Michigan about that.
If it's paid off, though, if my back is paid off, which is what the SARA loan said, or SARA program said, it would be paid off plus 3 months in advance. And I had to pay like $160, which I can pay tonight. It doesn't, I mean.
Those are all things that you should discuss with the property manager.
Okay.
At Meadow Lane, okay?
Okay.
And they can run that through their attorney to see if that all makes sense, okay?
Okay. Thank you, Your Honor.
All right. Okay, well, thank you. I'm glad that you were able to get in and before we were done this morning. So, all right, thank you.
Thank you.
Okay, let's go back to the McClellan versus Dalkey matter. And Mr. Dalkey, have you had any conversations recently with Mr. McClellan? You're muted. If you could please take yourself off mute.
Okay. Can you hear me now?
Yes.
Okay. Sorry, Your Honor. As of recently, I have not had any communication with Bradley.
Okay, are you still living at 917 South Division Street, Apartment C?
I am.
Okay. Let's see. So you have no idea why Mr. McClellan is not here this morning then?
I do not. Yeah, I mean, surprising to me because he's the one who set this up. So,
All right, well, it is now 9:23 a.m. The case was set for hearing this morning at 9 a.m. and the plaintiff has failed to appear. What I'm going to do is dismiss the case at this time for fail to prosecute, but without prejudice. And if Mr. McClellan were to contact the court sometime today, I would most likely set aside that default and put the case on our next docket for August 2nd, okay?
okay.
But maybe he's decided that the situation has changed and he doesn't care to pursue the case at this time. I don't know, but it might make sense to reach out to him and get things hammered out.
Yes. I doubt that that's the case, but I will try to send him a text and see if I can get through to him. I mean, I realize that he wants me and my son out of here, and I am actively looking for a place. But you know, as far as rent or anything like that, I'm all caught up on everything. I don't owe him a penny, so you know, there's no situation like that in my particular case.
Okay, well, that sounds good, and maybe he's just changed his mind about the circumstances. Who knows? But anyway,
And if he
for
doesn't
now,
contact you today,
well, then the default would enter, and it means the case would be dismissed. He'd have to start a new action all over again too.
I see. I see. Okay. Thank you very much, Your Honor.
All right. Sure thing. Feel free to sign off at this time.
Okay. Have a good day.
You too. All right. We'll be in recess then until our 10 o'clock hearing. Ayers Investment.
Judge Cooney, what happened to the North